Rebecca Reed, thank you very much for joining us. So I turn now to Katerina Tsibouklis, who's with me in the studio. The proposals that you've seen so far, do they have your support? Do they cause you any concern?
I do have some concern. I think the system as it is does work ultimately. And the potential for these proposals is that they will kind of put in place more stringent measures to effectively ensure that complainants are protected throughout criminal proceedings. Generally, this is to be welcomed because, of course, this is a very sensitive area. And, I appreciate Rebecca's point that, we need better training. This is a cultural issue. But we must also bear in mind that defendants are on the back foot from the moment they're arrested. They're already at a massive disadvantage because they've been arrested and because these kinds of cases carry so much societal stigma. And there are a lot of jury kind of preconceived notions about a defendant in these types of cases. They may come into court and sit in the dock with the dock officer next to them, sometimes from prison. And so, the jury may form a view of the defendant, before any evidence has even been heard. So whilst it's important we have these protective measures in place, we must remember that the onus is on the prosecution to prove their case against the defendant. And so it's important that we bear in mind that kind of the credibility of the complainant is a live issue in any case of this nature.
Given that this is a crime that most frequently occurs behind closed doors and therefore comes down to believing one version of events or another, are you dismayed by the rate of cases coming to trial and by the conviction rate, or do you think that's kind of what we should expect, given the nature of the crime, given the nature of trying to prove what happened in that event?
I think if we get too focused on conviction rates, on securing conviction rates, we end up in a very undesirable position. And that position would be, potentially infringing a defendant's right to a fair trial, which has to be the fundamental principle in the UK criminal justice system. We have one of the best justice systems in the world. And I think, it's really important that we uphold a defendant's right to a fair trial and we presume that they are innocent until they are proven guilty. At the moment, anyone accused of these types of offences can have their name plastered all over the news and almost end up in a kind of trial by media situation. That's not to say we shouldn't protect complainants. We absolutely should, and we should certainly...
How far can you take that? For example, is it legitimate for a complainant to be cross-examined?
I think it's perfectly legitimate for a complainant to be cross-examined. I think they should be cross-examined. The current system we have means that there is judicial oversight over the kinds of questions that a complainant can be asked in a criminal trial. So those questions are proposed in advance of the trial by the advocate, and the judge can kind of question whether or not those questions are necessary and relevant to the case. But it's important that we have that process because as a defence lawyer, we know how important it is that you can put forward your case in a criminal trial to ensure that the trial is conducted fairly.
And what about going to the credibility of the complainant? I mean, I think of things like records of text messages and things like that. Is that a vital tool for the defence? Absolutely.
Of course, that is always going to be relevant. For example, we see that at the moment, as part of the disclosure process, the prosecution will have to tell the defence if, for example, the complainant has previously made a false allegation. We may learn information about the complainant's previous sexual history, and all of that is important to any criminal trial. And if a complainant makes this type of complaint, it's always important that we ensure that they are a credible witness and that the jury is able to properly test their evidence, which means bringing them into court, it's safer in certain circumstances where it may not be appropriate, but bringing them to court, asking them questions, and the jury being able to form a view of them as a witness.
Katerina Tsibouklis, thank you very much for coming in on a Sunday morning, Sunday afternoon, and talking to us about this very, very serious subject.